Marbury versus Madison. Article 3, Section 2, Clause 2 of the U.S. Constitution gives the court its powers, which are original jurisdiction and appellate jurisdiction. Prior to the Marbury versus Madison case, there was no specific judicial review power given to the Supreme Court through the Constitution. What happened in this case was that outgoing President John Adams, there was the Judiciary Act of 1801, where new circuit courts were established and other courts were established, and there arose a need for several judicial appointments. So John Adams appointed several people as judges. However, and Marbury was one of those people. However, his commission wasn't delivered on time by the new Secretary of State, Madison. So when the new president, Jefferson, came in, he declared the appointment was void. So Marbury filed a writ of mandamus with the Supreme Court, basically asking the court to appoint him to his position, and he basically just wanted to be a justice of the peace. The Supreme Court ruled that Marbury had the right to his commission, but they couldn't grant his writ because the law directing to do so was unconstitutional. And the law that directed them to do so was based from the Judiciary Act of 1789. So when the Supreme Court declared that it was unconstitutional, they, in essence, took away some of their powers, but also gave themselves more powers by giving themselves the power to review these cases. So that's how judicial review was basically came about. So the impact of judicial review is basically that, for example, with Brown versus Board, they were able to declare segregation unconstitutional without having the original jurisdiction or without it being an appellate case necessarily. But it allows for the courts to keep checks and balances in place, and I think it's a great thing. The one thing that I would like to change would be for the courts to take cases that sometimes they say are too political. For example, things that have to do with immigration or the Muslim ban, things like that. I think that it's important for the courts to kind of set a precedent in determining and letting the states know what is and is not acceptable and what they should and should not be doing.